Good afternoon, everyone. Can Ayesha hear me?
Yes, I can.
Wonderful.
Afternoon.
No, wonderful, wonderful. I see we have a full house. There's quite a few participants in already, so we can start. I have a bunch of questions which the participants have inserted into their registration form. I'll just show it on the screen quickly so we can all just be on the same page. There's a 13 in total. So we'll try to get through all 13, and should we complete all 13 within the next half an hour, we can start taking some live questions where the participants can type in some questions. So let's begin. My name is Mohammed Abduroaf. I'm a practicing advocate in the Western Cape, Cape Town, and I specialize in various aspects of law, but I'm a family law expert. With me, I have Ayesha Karim. She's an attorney from Durban. Ayesha, would you introduce yourself, please?
Afternoon, everyone. My name is Ayesha. I practice in Durban. I have a law firm and we specialize in family law. So we deal with various aspects of divorce, maintenance, access, and all other aspects of family law. So look forward to helping you guys answer these maintenance questions this afternoon.
No, wonderful, Ayesha. Ayesha, I think we'll jump one time into it. I'll just put the question back onto the screen. Okay, so the first question is my child's father liable for any cost that I've incurred during my pregnancy and since he denies paternity and disappeared 7 weeks ago? So I think we're going to the scenario as to whether or not a father is responsible for maintenance for the laying expenses, for the birthing and pre-birthing costs. Ayesha, maybe you can jump into that quickly.
So I think the Maintenance Act is quite clear. So you're not liable, the dad wouldn't be liable for the mum, as in for her expenses for being pregnant, but most certainly for the cost of the birth itself, which obviously needs to be proven, and certain expenses relating to the birth of the child. Yes, so dad would be equally responsible. You would need to, and this is the part where I think a lot of people get it confused, having a liability in place. So if dad is obliged to pay certain costs, that's all good and well, but without a court order in place, so we need to differentiate between the two. Yes, he'd be required to pay those expenses, but then it would be up to the mom to then approach the maintenance court and say, these are the expenses that I've incurred and that I would like to obviously have a maintenance application brought against the dad for the respective expenses, and those would need to obviously be proven. And I see this particular woman has asked regarding the paternity, so he's denied the paternity. Counsel, I'm not sure if you want to perhaps answer that part of the question. What happens when dad has denied paternity of the child?
Now, say the father denies paternity, the court must first determine whether or not he is the father. Obviously, you can't have a person just alleging somebody is the father and he's not the father and he's paying for the child is not his. So the matter will basically be held in abeyance. It will be stayed, and they will postpone the matter demanded for the paternity test to take place. Should the results be negative, and then too bad, she has no recourse against the gentleman. But obviously, if he is a father, then the court will proceed with the whole inquiry, and she can claim for those laying expenses for the child. Okay, so I think that sorts out that specific question. We can move on to the next one. I've reported it years, but no movement is happening, and my matter is basically taking 2 years. How long? What can she do? How can she take the matter further? So Ayesha, maybe I'll just start with the matter with that specific question. I think the bottom line over here is the maintenance courts need to up the games, and the obligation is upon the maintenance court to deal with this type of matters very expeditiously. So the only advice I have to the specific person is go to the maintenance course, hassle them, and let them do their job. Let them do what they are paid to do. Ayesha, want to add something to that?
Okay, so I am going to add a bit more because obviously a lot of my work is in the maintenance court. So just a few tips on how we can get this resolved. It's a very common problem. I don't know if that makes you guys feel better or worse. It's a very common problem, especially with arrears, on trying to recover the arrears amount or to get the legal recourse that's available to us to actually get some movement going is very difficult. So the number one thing is trying to trace the dad sometimes can be an issue. Now, I'm not sure, a lot of people don't know this, but the courts obviously have their own systems, their own investigators in place who can trace dad and get a proper address for him or place of employment. However, you can, for a few $100, you can get a tracing agent to find his whereabouts, find out where dad is. And that would obviously assist. And mom, so what I'm trying to say is be proactive. You know, you're dealing with a department who is inundated with applications, who obviously they don't deal with one and two, they deal with hundreds of cases a day. So if you can be proactive in trying to get your matter to move a bit faster, please do so. You know, complaining about the fact that the maintenance courts, you know, are slow, we know that. You know, the fact that they're not perhaps up to date, they're not giving you the results that we want, we know that already, but that's not going to give us the solutions that we're looking for. So the one is, if find out what's the issue. So number one is that you can't trace that. Is that why we're not getting any headway with the courts? If that's the case, get a private tracer. I think it's in Durban, it's about 400 rand, you know, to trace him, to find out where he is. Has he not been brought to court because they can't serve him? So, you know, there's so many different aspects. Find out from the courts, what is the cause for the delay? Why has he not been brought to court? Have you informed the courts if he has property? Does he own a house? Does he own a car? Does he have a pension fund? You know, and then that would obviously assist the courts and assist the investigators within the courts to do their jobs. So it's about being your own advocate, especially if you're running your own matter and you don't have an attorney or you can't afford one. Then it's about being your own advocate and going forward and saying, these are my rights. Tell me, what can I do to assist the court, or what is the problem and what's causing the delay, and how can I find a way to help resolve that? And once you, I know I'm going into a bit of detail here, but once, and I noticed this, when two people are married, you know, nobody knows that person's whereabouts, the family, the hidden stories better than the ex-spouse, you know, usually. So you're probably going to have to be able to give the court a much better indication of where this person is, opposed to their investigators and their processes. So it's about assisting the courts as well to getting your case heard as fast as possible.
Ayesha, thank you for that in-depth answer. We have a live question which I maybe want to deal with. I have a question. The respondent keeps delaying the court hearings in Cape Town because he moved to Durban. So I presume that the mother lives in Cape Town. I applied for maintenance last year and he only appeared once at court, which was postponed because he did not bring his papers with. He delayed again, saying he's unemployed and can't afford to travel. Can he do this while my son of 2 years old is suffering? What would you advise a specific mother to do? She lives in Cape Town. The father lives in Durban. He's not really partaking in the whole process. Do you have any advice? And I'll jump in after that.
Okay. I think when it comes to unemployment, that's a tricky one, because obviously in order to have a maintenance order in place, one, the person needs to be employed, you know, or have some sort of income or assets that we can use in order to maintain the minor child. I know that there is legal recourse that's available where if he can't, and I've had this, and I'm not sure if I'm jumping the question here, but she said she's in Cape Town and he's in Durban, and he hasn't come down on it. And I know that this question comes out quite often during the pandemic. A lot of people are unable to travel or just not willing to travel. They're not willing to take that risk and travel for the purposes of hearing the matter. Now, I do know that, you know, electronic service and electronic communications are now becoming a pretty big norm in courts. Whether that's filtered down to maintenance court or not remains to be seen. In Durban, no, it has not. But I think, you know, going forward, the maintenance courts need to start looking at other avenues to get people. So if his excuse is, well, I can't travel because I'm, you know, across the country, I'm unemployed, then we've got to find a way, whether it's via video. I know the high courts are quite up to date with that, whether it's via video conferencing. This was so simple, counsel, I'm sure you'll agree. Then the maintenance courts need to come on board and say, okay, you can't come in, then we're going to do a video conference with you to discuss how we're going to, you know, take this matter forward. So that's my take on that. Unfortunately, there isn't much you can do unless you have a better idea.
No, I agree with you with that is concerned, Ayesha. I think the courts have to be creative. They have to make use of technology as well. And the same with the prisons as well. I mean, if a guy is incarcerated and there's no need for him to come all the way to the court, they have a video conference between the prison and the magistrate in the court. So that expedites matters. But I think for this specific listener, I think she must just be proactive as well, as you mentioned earlier on. You know, he is in Durban, she's in Cape Town. Follow up, hassle the maintenance officer, and see what happens based upon that. But don't just leave matters. Don't wait 6-7 months and then follow up. Do it immediately. Correct. And my experience is also sometimes the maintenance court themselves are a bit lax and delayed. actually many other times. And if the mother or the father is proactive, things happen much better, much faster. I'll move to the next question. I think I'll just put it on the screen, share it on the screen. Okay. The third question, what happens if he refuses to pay the amount requested, even if she proves that he can afford it based upon bank statements? I'll maybe answer that one quickly. The maintenance court has an obligation to make an order that's fair, reasonable, taking consideration what the parents can afford. So if you have proof that the father can afford to pay that amount of money based upon bank statements and the court is convinced, the court will have an obligation to make an order in that regard. Ayesha, what do you have to say about that?
I agree with you 100%. Just the one little thing I want to add in is, so you've come to court, you've proven your baby's expenses. Remember, that's only the first leg of the maintenance application. The second leg is then proving what can each parent afford. So it's not that my child, it costs me 7,000 Rand to keep this child fed and clothed, etc. So dad must just pay the 7,000. That's not how it works. The second leg of it is, what are you earning? What is dad earning? And then we work out what is each party then liable for in percentage-wise towards the minor child's expenses. So that's something you need to consider. It's not necessarily that he'll pay the full maintenance because you've proven that the child's expenses is X amount.
No, that's 100% right. Ayesha, we have another question. It says the following: I've moved residents, can I also move the courts? I'll quickly answer that. Yes, of course, maintenance application or the court jurisdiction applies to whether the carer, for example, the mother, lives or works. So if she lived in Johannesburg and the maintenance order was made in Johannesburg and she moved down to Cape Town, she needs to approach the Cape Town Maintenance Court to request a file from Johannesburg. Is that correct, Ayesha?
Yes, 100%.
Okay, so we'll move on to the next one, which you will answer. I have an existing court order which stipulates an annual increase. The father has this year applied for deduction. While we were at the maintenance officer said the annual increase are not allowed. Is this true? Please shed some light. I don't know how you interpret that question, Ayesha. Maybe you can elaborate on that issue concerning a reduction and an annual increase.
So let's twofold. So one, first of all, if the court order says there's going to be an annual increase, then there's going to be an annual increase. The maintenance officer does not have the authority to override a court order. So sorry, whoever the maintenance officer is, it is what it is. The maintenance officer cannot tell you that there's no increase if the court order says that there's an increase. Insofar as the reduction goes, that's a separate issue altogether, and that would need to it needs to follow its course. But yeah, so that's my take on it. I'm not sure if you'd like to add.
No, that is fine. And Ayesha, I think the next question, which I'll put onto the screen, is a question which I come across a lot, and sometimes it's not easy to answer. If you just share it. There's one regarding the third. You go to court, you go to the High Court, and you argue and you litigate against your opponents, and they keep on mentioning, 2/3 to an adult and 1/3 to a child. Now, I over the years, over the 15, 17 years, I've been dealing with child maintenance matters. I never grappled around that specific concept, because if the child uses 90% of the expenses of the household, then he must pay 90%. 90% is allocated to that. If the child uses 10% of the expenses of the household, then 10% should apply. What is your view on the third?
Okay, so the way I interpreted it, and it's really just a strict way of interpretation, is if I had to, and I say this to clients, certain things we can allocate 1/3 for. For example, rental. If you're living in a 3-bedroom house or 2-bedroom house, then you can allocate 1/3 towards the child. But then again, if you're looking at it and it's one parent and there's 4 children, how do you allocate? Then the children are taking up more space than the adults. So it's exactly what you said. It doesn't make much sense in that regard. As well as the electricity portion. I have, 3 very vibrant children of my own, and I can guarantee you my children use up more electricity than I do. I can guarantee that. So, when you approach the courts and you say the 1/3 portion, that's just a guideline to help you ascertain when we're trying to ascertain what are the costs for the minor child. I take it as a guideline, but of course, if you can prove that, although the 1/3 is a guideline, if you look at the facts of the matter, is mom works the whole day, she comes home and she's usually to bed and not even watching anything, and the kids are at home with the nanny or whoever it is, and so they're using at least 80% of the electricity city. That's the way it goes. I think the 1/3, as far as I have understood it to be, is that it's just a guideline so that we can help apportion expenses.
And I think I'll use a 1/3 to my advantage. So if my, if my client favors the 1/3 principle, I'll argue it. If not, then I'll argue the proportional. I think as an advocate, let's go to the next question. Okay, I've highlighted it. Each child maintenance applied respectively if no maintenance agreement was in place up at the point of an application for child maintenance. So the party applied for child maintenance when the child was maybe 2 years old. Does the order apply since the birth of the child?
Respectively. So no, court orders do not apply retrospectively. So when you apply for maintenance, the maintenance is to calculate the current costs of the minor child, and to put an order in place for maintenance currently and also for the future. Insofar as arrears maintenance is concerned, if you don't have a court order in place, then of course the maintenance court is not going to be able to assist you.
Yes, I agree with you 100%. Ayesha, I've applied it in Weinberg Maintenance Court a few years ago, and whereby if you look at section, I think section 6 something subsection of the Maintenance Act, it says the court, the first time you apply for the maintenance court, the court can make an order from the birth of the child until the date of the application is made. I tried the principle once in the Weinberg Maintenance Court, and the court said we don't do that. We've never done it before. So I applied it. So I applied a section and I argued it, and the court actually granted to me. So it's a lot of dispute regarding whether or not you can apply for maintenance, not to respect the order, but for court to make a lump sum order, expenses which have incurred since the birth of the child. But you can only do that if there is no maintenance order in place. But that's something we can discuss at another point.
Yeah, and I just want to add to that is just very quickly is that's exactly the point, is that the Maintenance Act is quite wide and it allows for a lot of things. I've noticed in practice, though, that the maintenance courts, although the Act provides for it, they're very reluctant. And like you said, unless you're prepared to go there and argue the matter on your point, you're not going to get much headway from it. But I agree that is a possibility if you're prepared to argue it.
Ayesha, thank you very much. I see we're moving very fastly. Question number 8 is a bit long, but I'll read it out. Can the respondent in Durban keep postponing a Cape Town-based maintenance matter with the reason of travel restrictions permitting me to travel and I am financially unable to attend? I applied for maintenance last year, November, and each time I think he keeps postponing due to financial circumstances and has no desire to be part of the baby's life, and yet refuses to grant me full custody. Your assistance would really help. Thank you. So I think the scenario goes over here. One party does not want to come back to the court to partake in this whole process, and the other party is refusing contact. Any comments on that?
Look, I think I've already mentioned the issue of traveling and electronic communications in the courts. As you can see, it's an ongoing problem. I'm not sure if you want to add to that. I think I've said quite a bit on that topic already.
No, Ayesha, you have done that. I'll go to the next question. Question number 9. Hi, I have a court order for child maintenance. My ex remarried and stopped paying. He has, in the meanwhile, had another child and claims he cannot afford to pay child maintenance. He left work to become a real estate agent. I refer the matter back to court a year down the line. He has still not paid. The matter keeps on getting postponed. How can I fast track the matter at court as they are now using the COVID pandemic as an excuse? So we have a scenario here where the father remarried and he's now saying he can't afford to pay for the child. My view on remarried, of course, if a parent has another child, obviously we have to now relook at the whole situation. Previously, before he had the second child, he could afford to pay certain expenses towards the first child, but now that he has a second child, he has an obligation to pay maintenance for the second child as well. Obviously, the same regarding the pandemic comes in. Any comment on that, Ayesha?
Okay, well, a few things. One, if there's a court order in place and he can't afford the maintenance anymore, then the onus is on him to approach the court and say, I now have another child, and obviously I need to apportion my salary accordingly, or my salary has changed, my lifestyle has changed. So that onus is on him to approach the court. You can't unilaterally decide, well, I can't afford it anymore, so I'm going to ignore the court order. We can't. That's not how it works. So that's point number one. And then the second point is she's asking, how does she fast track her case? If there was a magic button to push, I would have done it many times in my career, but unfortunately there is not a magic button to push. You do have to just follow the process, and there's different types of recourse available. So I did say this in our last live, but I'll mention it again, is obviously there's criminal sanctions that are in place, or that penalties in place regarding criminal sanctions in place regarding non-payment of maintenance. So it's very serious. So if somebody has not paid maintenance, you can take criminal action against them. I don't think anybody would want to have criminal action taken against them for the non-payment of maintenance. The second one is obviously you can attach his salary. If actually he's an estate agent, that may not be possible, but obviously he may not have other assets available, whether it's policies or immovable property, or even paid off vehicles. Anything of that sort can be attached. So it's about you, like I said at the beginning, being your own advocate and approaching the court and saying, this is the arrears amount. He has not approached you to say he can't pay, or he's not willing to pay, or that he can't afford it. Therefore, the courts must do their job. And either we need to follow the civil recourse and have his things attached, or criminal action needs to be taken against him. But you're going to have to be a little bit proactive in the process and approach the courts and start putting a bit of pressure. Remember, it doesn't end with the maintenance or the clerks. It doesn't end with the maintenance officers. There's a maintenance manager. There's magistrates. There's a senior magistrates. So you've got to really push for. There's a prosecutor. So for example, if you're going to take the criminal route, there's a prosecutor that you can speak to. There's a senior public prosecutors that you can speak to. So you've got to know your way around, and you've got to educate yourself, especially if you can't afford an attorney. You're going to have to do this yourself, and it may not be easy. And definitely, if you're going to just leave it and wait for the courts, you will wait years before you get any sort of recourse.
Yes. No, I show you 100% right. And furthermore, you can even go beyond the court. You can go to the director of public prosecutions. You can go to the local minister of provincial minister of justice as well in the province. If you make the noise, they will come down and make noise below. Another live question we have. Hi, I am a year into maintenance hearings with my ex not producing documents at the hearing. We have subpoenaed him and his parents as witnesses, as the father has taken care of a lot of our expenses during the marriage, and the ex has transferred all what he owns onto his mother's name. I now have warrants of arrest for his parents, and now they have approached me for a settlement out of court with the value of the amount of the current interim maintenance. Is it advisable to settle out of court, or should I risk the chances of getting more or maybe less than what I have in terms of the current order? So what is your advice over there? I think the scenario over here is that the father and his parents are non-compliant with the direction of the magistrate to come to the maintenance court. They're now willing to pay all the arrears for the matter to be settled. Do you advise the viewer here to proceed in the maintenance court what you actually want, or settle on what they have offered?
So my advice when it comes to minor children, and especially in matters like these, I always try to take the settlement route. I find that always to be the best route forward. However, under the current circumstances, if she is going to accept a settlement, the ball is in her court. So if I were her, and if I was her representative, I would obviously aim high. If you're going to settle, they must come very close to the full amount of whatever the arrears is. And then obviously going forward, she needs to ensure that she's going to be protected, or the child is going to be protected going forward. And there needs to be a concrete court order in place going forward to avoid this from reoccurring in the future. So there's a lot of moving parts involved. It's not a situation where, okay, yes, let's just take this all out of court and have an out of court settlement, and it's going to be between us. I know a lot of families prefer the out of court settlement. That's not going to benefit her or the minor child. If you're going to take your settlement, do it, but try to get the best amount possible, and then secure yourself through the courts going forward. That's my advice. I'm not sure if you want to add to that.
Yes, I think, the mere fact that the parents and the father were, from the word go, non-compliant, now they come to some type of settlement agreement and out-of-court settlement agreement. What stops him from tomorrow, in a few weeks' time, to continue how they've been, conducting themselves? So a proper inquiry will make more sense. If the settlement is reasonable, see what the maintenance officer said, see what the magistrate has to say, and if they believe it is reasonable under the circumstances, why not make it an order of court?
Sure.
I think that's some good advice to the participant. The next live question with the participant put into the chat is, what if the current costs are drastically below the actual needs of the child due to the income of the mother, and the children lived a much more comfortable standard of living, and the father continues to have the comfortable standard of living? I don't understand the question so well, but I would presume is that the fathers are living a good standard of living. They used to live a very good standard of living while they were together, but now because of mother's earnings, she's unable to give the child that specific standard of living, and the father's not paying that amount of money. I think the issue over here is post-separation, what does the law say regarding the standard of living of the child?
So I think insofar as the Maintenance Act goes, is that the child must be kept within a reasonable standard of what they are used to. So, and I always use this as an example, and I say, if your children were going to private schools and that's all they've known since grade 00, and in private schools there's 10, maybe 15 per class, you absolutely cannot take a child that's been in a private school their entire lives and then say, sorry, you go all the way down to a fully public school, so that's the first leg of it. They've got to be kept within reasonableness to the same standard that they were used to. However, practically speaking, and I see this a lot in my practice, is that we are taking one household and we're essentially dividing it in two. So practically, to keep the standard of living exactly the same often is virtually impossible. And it's virtually impossible because now we had one set of household expenses, one set of bond repayments, etc., one electricity account, and now we have two. So to keep the exact same standard of living is impossible, but I think most certainly not it cannot be, where the children were living in the laps of luxury and, mom had an expense account of, 50,000 a month, and then we go down and say, well, dad's now going to offer 500 Rand a month. That's totally unreasonable and unrealistic. So within reason is my response.
No, I agree with 100%. Ayesha, obviously, while they were together, there was one rental expense, one bond expense. Now there's two bond expenses. Now there's two cars. Now there's two of everything. So obviously, that will definitely affect the numbers. Before we go on to the one more live question online, I think we have to go back to the questions that people posed before. Let me just put it onto the screen. Okay. I have a court order for child maintenance. My ex remarried, so I think we dealt with that. Number 10. What if the father of your children is unemployed by choice, but he has various properties which he earns retail income from? I think we'll stop it over there. I think I know where this is going to, where someone is not earning any money, but he has a lot of assets. Does the law look at the person's assets as well, or does the law only look at your salary or income? Ayesha, any comments on that?
Yeah, well, I think that's pretty straightforward. Yes.
Yes. So my understanding of that.
No. Yeah.
Yeah. Yes. Many people out of their own, they leave employment for the sole reason. I'm saying that, so that they cannot pay child maintenance because they have a relationship with the other parent. But they put the money into policies, in investments, in whatever it is, the case may be. So when it comes to child maintenance, we don't look at your income, we look at your means. So if your means entails having assets, cars, property, etc., we put an amount to that. Ayesha, we agree with that? I think you would. Hopefully you would.
Yes, I 100% agree. And I think the Maintenance Act also allows for, when we're attaching assets and considering the means, I know it happens quite often when we have pension funds that we're attaching, you can actually attach for future maintenance. So if dad is unemployed, but he has, a fund available, or pension fund or a policy, we can actually attach for some amount of future maintenance, so that mom doesn't have to come back next month to the court and say, okay, the maintenance is now gone, what do I do? So you can attach for a certain amount of future maintenance if he has assets available.
Well, thank you for that, Ayesha. Ayesha, the next question online would be, my ex doesn't pay maintenance even though we had a parenting plan with lawyers. I think the quick answer to that would be, then if he's not paying maintenance and if the maintenance order in place, you need to go to the maintenance court and lay complaint for non-compliance. If this parenting plan agreement has not been made an order of court or registered with the Office of the Family Advocate, we advise you to urgently approach the maintenance court, or to have that parenting plan made an order of court or registered, which have some type of legal effect.
100%.
Thank you, Ayesha. Ayesha, last question on the people registered. A lot of people, when they register, they they left it blank, how to apply for child maintenance, but that was a default insertion into the form. So the last question will be, how do I apply for child maintenance? What is the minimum amount payable for maintenance? What can a mum claim for maintenance? Example, food, school fees, medical expenses. Ayesha, I'll leave that one to you.
Okay, so there is no minimum amount. It's dependent firstly on what are the reasonable expenses of the minor child. And then the second leg of the test would be, what is the income of both parents, So there's no minimum amount, there's no maximum amount either. Especially in a country like South Africa, where we have the very elite and the very rich, and then we have, of course, the working class, and those that are on the lines of poverty. So there is no minimum amount. It depends solely on what is reasonable and necessary for the child. What kind of expenses can you claim? So you can actually, and I advise this to my clients, you can actually download the maintenance application forms. It's online. So many of my clients do it. You just download it online, and it actually breaks it down for you quite nicely. So it'll tell you domestic worker, I think there's even DSTV on there, rental, food, groceries, toiletries, clothing, etc. So the maintenance application form itself, essentially, if you just read it, it's quite self-explanatory, and it shows you exactly what you can claim for the minor children.
Wonderful. Thank you for that. Ayesha, I think we've met over our time. I think we dealt with 20 questions in a period of 30 minutes. Obviously, had we charged these clients for this, would have taken most probably 5 hours for 5 questions, but because it's a community thing, we're taking much faster. That's just a joke. Okay. Ayesha, anything you want to add on your side before we?
No, I did see a question. I did see a question come up that says, can we please share our contact details? So council usually puts up our details at the end. I think my contact details and his. We're both quite tech savvy, so you can get us. Although he's in Cape Town and I'm in Durban, we handle matters together quite efficiently, if I do say so myself. So you can. I think our details will be on at the end of this webinar. And you guys can contact either of us on our emails or on our respective numbers. In closing, I just want to say thank you so much. This has been really wonderful. I'm glad we got through so many questions. I see there's more questions coming up. But yeah, this is wonderful, and I hope we've added some value to the listeners this afternoon.
Ayesha, thank you very much for your time. Also, I know it's very hard. I know you're still going to be busy from Monday till Saturday, and this afternoon and this evening will be busy with other work. But thank you very much. And yes, correct. All the people that registered for this webinar will obtain a link to this video, and in the video itself, we will have all the details of myself and Ayesha. To all the participants, thank you very much. Have a wonderful weekend, and we'll advise you soon on the next webinar. Bye-bye.